There are a couple of concepts that are very particular to commercial leasing, and they have their own nomenclature. But they're important concepts to try to protect the tenant's rights. Essentially, what a lease is a series of property rights and common law rights on top of which you put a contract. So you now have this amalgamation of law that washes through it. In that amalgamation of law that becomes your lease, there are certain concepts that are protective concepts for both the landlord and the tenant. And they seem strange because they're vernacular, but things like estoppel certificates, things like subordination and non-disturbance agreements, or SNDAs, things like notices of lease, are all protective concepts and there for a purpose, and if structured the right way in a lease negotiation, benefit both the landlord and the tenant. And why it's known as an estoppel certificate, because having given that statement, landlord to tenant or tenant to landlord, it estops the other from coming back and saying, well, you've been in default for the past 3 years. You now have a definitive point in time where you can say that, hey, this is what the lease was, we both agreed to it, and we're both going to abide by the fact and rely on the fact that we have a good lease between us. That's all an estoppel certificate is. A subordination and non-disturbance agreement is a document where frequently where you have lenders and you have tenants, it's one of those amalgamation of property rights that I was talking about. Who has superior rights over who else? The only thing a tenant really needs to know about a subordination non-disturbance agreement, an SNDA, is that the tenant wants to have non-disturbance rights in it, so that if the landlord goes bankrupt or the bank takes over for any other number of reasons, that the bank would have to recognize the lease and honor the tenant's tenancy under the lease. That's what the ND, non-disturbance aspect of an SNDA is. The subordination protects the lender and protects the landlord. So in that document, there's a push and pull that benefit both landlord and tenant, and the landlord's lenders certainly. And then finally, the third document, a notice of lease, is a document where if a lease is going to be enforceable against third parties after some period of time, usually by statute, usually 7 years, 5 years, 7 years in Massachusetts. If the lease is going to be effective against third parties, there has to be a notice of it put on the property records. And if you think about it, neither the landlord nor the tenant wants to take their lease and have their entire lease sitting there in public records so that everybody understands how much rent's being paid, how long the term's going to be. But a summary, known as a memorandum or a notice of lease, can be put on record that in effect establishes the tenant's place in that property and establishes it in a legal fashion so that the entire world has notice of it. And that's what a notice of lease does. Again, protective of both landlord and tenant. In that instance, a little bit more protective of the tenant.